Are we on?
Yes.
Oh, we're on now?
Yes.
Okay. Hey there. Welcome to PJ Big Picture Day 2014. We have some new things for you. This video will be posted to YouTube. Now, we'll be getting to this in a little bit. This is a coggle. You can make them for yourself if you find them helpful. The website is at coggle, coggle.it. And you can create your own toggles. This is kind of like a detailed flow chart. We're going to be using that for most of our discussion. But what I want to do first is kind of get back to the future. Now let me be clear. With our exams, with the bar exam, what matters is what is the law today. So to an extent, what the law was back in 1878 doesn't matter, unless it's still the law today. So I think for us to do PJ Big Picture Day, I want us to think about where things started, and then we'll see where they ended up. So a little refresher, okay? Pennoyer. First principle of public law. Every state possesses exclusive jurisdiction and sovereignty over persons and property within the territory. We now know that, for example, as the traditional basis of domicile over persons, right? We know this is the traditional basis of tag jurisdiction, personal service on an individual while voluntarily present in the form state. We know this as in rem and quasi and rem jurisdiction, right? You're in the box, you're in the state, you're subject to the power and jurisdiction. You're outside of the box, you're not. Then we have the second principle of public law. No state can exercise direct jurisdiction over persons or property without its territory. In other words, if a person or property is located outside of a state, then the state lacks jurisdiction over that person or that property. Now, we know that this was overruled, at the very least regarding persons, right, by international shoe, right? So we're going to get back to this, but as a starting point, we want to remember how things work. And even a reminder that even under Pennoyer, even though a state lacked jurisdiction over people found outside of the state, we still have the full faith and credit clause, credit clause, right? So if you had a valid impersona judgment from state 1, then you could enforce it against property found in state 2, right? So if Mitchell had sued Neff in California, where Neff could be found, then Mitchell could have gotten a valid impersona judgment against Neff. Now let's say Neff had no money in California. Where did Neff have money or property? Oregon, right? So you get that valid judgment in California, and then you take that magical piece of paper, the judgment, you take it to Oregon, and use the full faith and credit clause to enforce it, okay? So that's just a little peek, a reminder that even under Pennoyer, you could still affect people in one state by getting judgment in another state. So that's where we kind of start off, right? What I want to do today, however, is we'll come back to this stuff. We'll come back to Pennoyer. We'll come back to the first principle and the second principle, particularly in the context of Shaffer, regarding the current state of in rem and quasi in rem, and regarding Burnham, regarding the current state of tag jurisdiction. But for right now, what I'd like to do is move on to the coggle. So here we go. What I have in this coggle is kind of a multidimensional flow chart. The left-hand side concerns federal court jurisdiction, and the right-hand side concerns state court jurisdiction. Okay? Let's start off with federal court. And the reason we want to start off with federal court is federal court has some special basis for PJ that are not available in state court. However, the main basis for PJ in federal court is 4K1A, right? Which means whatever isn't good in Rome, well, let's put it differently. When in Rome, do what the Romans do, right? What works in state court also works in federal court. So here we are in federal court. Now, the two main categories of jurisdiction are in rem and quasi in rem on the one hand, and in personam on the other. In rem and quasi in rem are assertions of jurisdiction against property. In personam is a judgment against the person itself. And by persons, we mean both human individuals as well as business organizations, such as corporations, partnerships, LLCs, LLPs, and so on and so forth. Let's start off with something very simple. In rem and quasi in rem. Remember how I signed FRCP 4N, Federal Rule 4N? Relatively straightforward. We have two subsections here. We have 4N1 and 4N2. 4N1 tells us that if there's an applicable federal basis for asserting jurisdiction over property, then 4N1 permits jurisdiction over that property. But 4N2 is an example of what we'll come back to again and again, which is when in Rome, do as the Romans do. So if you're in federal court, you can also use state bases for quasi and rem or in rem jurisdiction. Namely, under 4N2, if personal jurisdiction is not available against a person, you can't serve a summons against a person in personam, then you can use applicable state law that would permit seizures of any assets found within that judicial district. So for example, if you sue somebody in federal court in the Southern District of Florida, but you can't get in personam jurisdiction against them, but guess what? They have that wonderful vacation home on South Beach, okay? Then 4N2 will permit you to use Florida state law to seize those assets and attach them pursuant to either in rem or quasi and rem jurisdiction, okay? Now, of course, if we're using the state basis for in rem or quasi and rem jurisdiction, that means we have to consider the limitations on state court jurisdiction as well, right? Think about Shaffer, for example. So see what I say right here? Look to right side bracket state court jurisdiction. So in other words, we're going to hold off on further discussion of this sub-issue right now, namely in rem or quasi and rem under Rule 4N2. We'll come back to this when we consider what is the current scope of in rem and quasi and rem in state court pursuant to Shaffer, pursuant to the various concurrences in Shaffer, and even pursuant to what the court says in Burnham. So that's it for right now for in rem and quasi and rem in federal court. Let's instead move on to the meatier in persona branch, right? And here we, of course, turn to Rule 4K. Now, 4K has a number of bases. Perhaps the most important of all the bases in Rule 4K is Rule 4K1A. And that's our archetypal, when in Rome, do as the Romans do. In other words, when you're in federal court, assess personal jurisdiction the same way would be assessed in the corresponding state court. So you file suit in the United States District Court for the Eastern District of Pennsylvania. That means you would analyze PJ the same way a state court in Pennsylvania would assess personal jurisdiction, namely pursuant to number 1, the Pennsylvania state long arm, right? And number 2, 14th Amendment due process. Why 14th? Because 4K1A tells us to assess PJ as if the federal court was a state court. And what due process clause limits state courts? The 5th or the 14th? 14th. The 14th. So 4K1A means you're in federal court, be like a state court. Look at the relevant state long arm and assess 14th Amendment due process. And in fact, most assertions of jurisdiction, even in federal court, are going to be assessed pursuant to 4K1A. That's the most common basis. You'll see federal court decisions all the time. We first, say it's a federal court in Florida, we first turn to the Florida long-arm statute, blah, 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 blah. Being that the Florida long-arm statute is satisfied, we now assess whether or not the assertion of personal jurisdiction will comport with the 14th Amendment due process clause, blah, 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 blah. Then the court will go on to discuss whatever basis or bases will be relevant under the due process clause. And we'll get to those when we move over to the state side of the coggle. Now here under 4K1B, 4K1C, and 4K2, we have special bases that are available only in federal court. Only in federal court. They can't be used in state court. And because these bases are only for federal court, the limitations on this authorization is not under the 14th Amendment due process clause, but rather under the 5th. Okay? Now something to remind ourselves as we go through these bases is that personal jurisdiction is basically territorial jurisdiction. 14th Amendment measures the territory of an individual, boom, 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 here's the box, here's the state, right? But when we're talking about the 5th Amendment, its due process clause constrains the power of the United States as a sovereign as a whole. And the borders of the United States are a lot bigger than the borders of any individual state. So let's turn to these bases. First, we have 4K1B, better known as the Bulge Rule. And there's 3 requirements under the Bulge Rule for personal jurisdiction to be okay. First, you have a defendant who joined under Federal Rule 14 or 19. Now, I know that we haven't actually gotten to 14 or 19 yet, but we've kind of discussed it, and we've had some examples of it. So, for example, P sues D, right? And then D brings in a third-party defendant saying, hey, third-party defendant, anything that I, the defendant, owe the plaintiff, you may owe me. Well, that's called third-party practice. Okay, that's Rule 19. Assuming we have somebody that's brought in by the defendant as a third-party defendant under Rule 14, then the first element would be met. But there's more elements. Second, the defendant must be served within 100 miles of from where the summons was issued. So here's a good example. Suppose, I'm not up on the geography here, but I seem to recall that Seattle, Washington is right near the border. Is that correct? Near the border of Canada?
Yes.
Okay, so Seattle is right up there, real close to the Great White North. Okay, so a plaintiff sues some other guy who caused a car accident. Okay, there's a car accident in Seattle. Plaintiff sues the defendant for negligence. And guess what? The defendant had bought new tires just a week before in Canada, okay? Right across the border, from whatever city is, what city is north of Seattle?
Vancouver.
Vancouver? Okay, Vancouver, where they record all the TV shows, right? So here the defendant bought his tires in Vancouver, and he's mad because he thinks that the tire dealership may have contributed to the loss of control of the vehicle, which in turn caused the accident. And now the driver, the defendant, wants to bring in the tire shop from Canada as a third-party defendant. Okay? Well, first we have a Rule 14 joinder of a defendant, right? So the first element is met. Second, let's say that the tire shop is served in Canada. Okay? So we have service take place in Canada. Say it's about 25 miles away from the federal courthouse in Seattle. Okay? The second element is met, right? The service on the third-party defendant happened within 100 miles of the Seattle federal courthouse. Would the Bulge Rule be satisfied? Yes or no? I hear, oh, that's a very, very tentative response. Go ahead, go for it. Yes or no?
No.
No, that's correct. Because I haven't yet gotten to element number 3, right? The third element is that the defendant must be served in a United States judicial district. Is Canada part of the United States?
No.
It is not. So Vancouver is not within the United States judicial district. Okay? So the Bulge Rule can't work. Now, what if we have the same hypo, but instead of the lawsuit being in a district in Washington, the lawsuit is in Tallahassee, in the United States District Court for the Northern District of Florida, okay? And the tire shop is not in Vancouver, Canada, but is instead in southern Georgia, 14 miles away from the Tallahassee courthouse, okay? And the tire shop is served in Georgia within that 100-mile radius. Would there be Bulge jurisdiction?
Yes.
Yes. What if I additionally told you that the tire shop in Georgia had no contacts or ties to Florida, had never sold any tires to anybody in Florida, had never marketed itself to Florida, didn't advertise in Florida, had no contacts to Florida whatsoever? Okay? Would there be personal jurisdiction over the tire shop in the Florida federal court?
Yes.
Yes, there would, because of the Bulge Rule. Because the Fifth Amendment reminds us the United States is bigger than an individual state. The Bulge Rule permits the borders of the Northern District of Florida to bulge out beyond the actual borders of Florida and to reach out within that 100-mile radius. As long as the person brought in is served within that 100 miles and they're served within the U.S. Judicial District. Is Georgia within the United States? The answer, of course, is yes. So that's the Bulge Rule. And this is, of course, is something that can't be done in state court. Why? Because it's territorial jurisdiction. State jurisdiction is measured by the 14th, and the borders do matter under the 14th Amendment. Next, and I'll just note this briefly, is Rule 4K1C. 4K1C says if there's a specialized personal jurisdiction statute, go ahead and use that. And we'll get to some of those in the spring. For example, there's a cause of action called Statutory Interpretation. I won't go into the details now, but suffice it to say that sometimes Congress, the US Congress, has created a specialized jurisdiction statute that says that a defendant may be served with process anywhere in the United States, okay? And that what you would have then would be nationwide PJ. Nationwide PJ, wow. One country, one sovereign, big territory, right? Permitted by the Fifth Amendment. And we'll get to that more. We'll remind ourselves of that when we talk about interpleader and statutory interpleader in the spring, which is a part of our studies of joinder. Federal, last one, the federal long arm, FRCP 4K2. All right? There's a number of requirements. First, the claim must arise under federal law. Second, 4K1A jurisdiction is unavailable in any state court. And third, PJ must not violate the Fifth Amendment due process clause. Let me explain in detail what each of those are. And give me a second. What I'm going to do is I'm going to switch away from the web page. I'm going to go over to this because I think it's be easier to work with. Here we go. Because I have a PDF copy of this as well. Here we go. I think this is going to work better. How's that? A little bit better? A little easier to see? All right. Claim arises under federal law. Guess what? There's a little bit of a subject matter jurisdiction within the PJ analysis, isn't there? P sues D for negligence. Can we use 4K2? What do you think? P sues D for negligence.
No.
Yeah, 4K2 doesn't apply. It's a state claim, right? All right. P sues D for copyright infringement.
Yeah.
Now we're good, right? Second, cannot have 4K1A jurisdiction in any state court, okay? In other words, there can be no state that would have PJ over the defendant. So suppose you want to use 4K2 jurisdiction, and you want to use 4K2 in the Southern District of Florida. Let's additionally suppose the defendant resides in California. The defendant is a domiciliary of California. Can we use 4K2 jurisdiction over a California citizen when the lawsuit is filed in the Southern District of Florida? What do you think? No. Why? That's right. There's going to be 4K1A jurisdiction. Maybe not in Florida, right? But California, yeah. So typically, not always, but typically, 4K2 jurisdiction is typically going to be limited to cases involving foreign defendants. I won't go into details. If you recall in class, we talked about the case of Mawani versus bin Laden, right? Where bin Laden and Al-Qaeda were sued in federal court in Washington, D.C., and the court used 4K2 jurisdiction, all right? The last requirement is that personal jurisdiction doesn't violate the Fifth Amendment. Here's what I want you to think about. Minimum contacts, but with what? Minimum contacts with what? A state? There should be minimum contacts. With what? The U.S. as a whole, right? Because under the Fifth Amendment, the relevant sovereign is not a state. It's all the states, the United States, these United States. So for 4K2 jurisdiction to apply, it's kind of a stopgap, right? It's a, well, last possible measure. That if 4K1 doesn't apply, 4K1A doesn't apply, then maybe you can use 4K2, but only if it's a federal question, right? And additionally, only if there be sufficient contacts with the U.S. as a whole. That's federal court PJ. Now, of course, that's not the whole story, is it? Because I've said, well, we'll get to this later, namely, in federal court, let us recall that we can use 4N2, which means when in federal court, they use a state basis for quasi and rem or rem jurisdiction, which requires us to consider the state analysis. And similarly, 4K1A, which says to analyze PJ in federal court as if you were sitting in the corresponding state court. So now we move from federal court into state court. And I'd like to proceed in the same order that we started with. We're going to start with in rem and quasi in rem. Then we're going to move into impersonum. Regarding impersonum, we're going to look at the state long-arm statute, and then we'll look at the 14th Amendment due process. Regarding 14th Amendment due process, we'll look at the traditional bases, and then we'll look at this humongous sub-part of the analysis, which is the minimum contacts test. So, starting with in rem and quasi in rem. Analyzing in rem and quasi in rem in state courts can be very similar to what we do for people. Okay, remember for people in state court, we look at what? The state long arm, right? And 14th Amendment due process. Well, it's kind of the same thing for property. So for property, first you want to ask, is there some law, typically a state law, possibly a federal one, but typically some state court rule or law that permits the seizure or attachment of the property? Okay, so think of the state long-arm equivalent, but for property, not persons. Some sort of attachment or lien statute or a seizure statute or a garnishment statute, something like that, okay? If that's met, then you have to ask whether or not the applicable law violates the 14th Amendment due process. Now, recall what we said about Pennoyer a few minutes ago, right? Under Pennoyer, it was enough for purposes of the due process clause that the property was to be found within the forum state, right? But maybe that's no longer the case. Why? Because we have international shoe, and because we have Shaffer, all right? So in Shaffer, Justice Marshall tells us something very broad, very sweeping. He says, heretofore, after now, all assertions of state court jurisdiction shall be analyzed under international shoe and its progeny. All assertions, right? Well, that's a pretty sweeping pronouncement. And keep in mind that he had a majority of the court, all right? If we accept what Justice Marshall says as being correct, that means that any assertion of state court jurisdiction over property, whether it's real property, whether it's intangible property, whether it's personal property, so we're talking a house, right? Stocks, an iPad, they would all be assessed under the international shoe minimum contacts test. That would mean at this point, we'd either have to do a minimum contacts analysis or say that I will later on analyze minimum contacts, right? However, keep in mind that it's quite debatable regarding the scope of Shaffer itself. There's a couple reasons why the scope of Shaffer ought to be seriously questioned. First, we have two concurrences in the Shaffer case, both of which noted that the case at hand didn't concern real property and wanted to reserve the question of whether or not real property should still be analyzed under the traditional Pennoyer rule. By this reading, real property would still be subject to in rem or quasi rem jurisdiction, so long as it was to be found within the forum state. Another reason to doubt the scope of Shaffer is because of what Justice Scalia says in the Burnham case. You recall that Scalia had a total of 4 votes, including his own, and he said, well, Shaffer only involved quasi and rem jurisdiction, okay? So by Scalia's attack, it may be that we ought to read Burnham as only applying to quasi and rem jurisdiction. In fact, in its narrowest reading, Shaffer would only apply the minimum contacts test to quasi and rem jurisdiction over things besides real property. So I suppose if you have something like this come up in an essay or in a fact pattern, you should think about what are the various ways of reading Shaffer. Shaffer itself is quite uncertain regarding its scope. It's an area where the law itself is not clear or settled. All right? So you need to be prepared to argue both the Marshall approach, which is to use the minimum contacts approach, and you also need to be prepared to consider whether or not the Pennoyer framework applies where jurisdiction is automatic so long as the property is located within the state. Now, regarding Marshall's approach, he suggests that we should analyze minimum contacts regarding property differently depending on the relationship between the property and the lawsuit, okay? And so in class, we kind of expanded his footnotes and his discussion to carve out 4 different kinds of property disputes and how they might be analyzed on the minimum contacts test. Number 1 was pure in rem action. Now keep in mind that pure in rem is when the property is itself the subject matter of the lawsuit and the whole world would be bound by the judgment. So think, here's an archetypal example of in rem jurisdiction is a probate proceeding, right? The property at issue would be the estate itself, and the whole world is going to be bound, all right? Marshall says in such a case there would usually be PJ so long as the property is located within the state. What about quasi and rem? 3 different types. Quasi and rem type 1 is when the property is the subject matter of the lawsuit, but the only people to be bound are the litigants. Say, for example, an agreement for the sale of real estate, okay? Well, what's at issue is who gets to own the property, right? So the property is the subject matter of the lawsuit. Who would be bound? Only the litigants, okay? Similarly to in rem, he says, usually there would be PJ. But there's other types of disputes as well, namely where the property is within the state, but the relationship between the property and the claim is a bit more tenuous. So first we have a quasi and rem type 2A. That would be when the property has some sort of relationship to the suit, but the ownership of the property is not the subject matter of the suit, okay? An example of that, as Marshall gave and as we discussed in class, would be when somebody owns property in a state, but they are not located in that state. So I own a vacation home in Alaska. Somebody slips and falls on the Alaska property and hurts themselves. The only jurisdiction they can get against me in Alaska is quasi and rem because I have no other ties or contacts with Alaska, but my maintenance of the property led to the claim. Okay? Well, they're not trying to get ownership of the property. What they want is damages from the alleged negligence. The property is related to the suit, but is not the subject of the suit. That's a quasi and rem type 2A. What does Marshall say? He says, there may be jurisdiction here. There may be jurisdiction. That's pretty helpful, huh? There may be jurisdiction. The final type of property would be quasi and rem type 2B. That's what was at issue in the Shaffer case itself. It's when the property is not the subject matter of the suit and is not related to the suit whatsoever. The only reason the property itself is being sued is because that's the only thing the plaintiff can try to grab, try to get jurisdiction over as part of the lawsuit. That's Shaffer itself. At least what the majority says, right? The stock was located in the state, but there were no other relevant contacts or ties that the individual defendants had with the state. Another example might be, it's one of the problem set, right? I own artwork or I own stamps that can be found within Georgia, but I have no other ties with Georgia, right? So the plaintiff attaches the stamps to force me to show up and defend. But they're suing me for something different that has nothing to do with the stamps or the artwork. That will be quasi and rem type 2B. Marshall says that the presence of the property alone without more is not going to be sufficient for jurisdiction. Now this is a pretty big break for Pennoyer, right? Because if my stamps or my artwork is found within Georgia under Pennoyer, then the court has jurisdiction over it because the property is located within the state. First principle, pure and simple. Shaffer would change things quite significantly. One last thing to note about quasi and rem jurisdiction is a holdover from Pennoyer, which is the property must be attached to the lawsuit in the lawsuit. You can't simply get a default judgment and execute later on, right? Pennoyer reminds us that you've got to attach the property to the lawsuit while the lawsuit is going on, typically done early, okay? Actual practice is going to vary from state to state. That's something beyond the scope of what we covered here. But what you can't do is just file a lawsuit, get a default judgment in personam, and then try to execute against in-state assets. Remember, that's what Mitchell tried to do against Neff, and the Supreme Court said that's not going to fly. All right, so we've done in rem and quasi and rem jurisdiction. Now we want to move into in personam jurisdiction. Remember, in personam jurisdiction is different from in rem or quasi and rem. First, in personam means suits against people. It also means suits against business entities, such as corporations, partnerships, and so on. In personam judgments are up to the full value of the judgment. Okay, so if you sue somebody for $1 million in personam and you win, then that's $1 million judgment. Okay? In contrast, an in rem or quasi in rem judgment is against the property itself, and is only enforceable against that property up to the value of that property itself, and no more. So if you sue somebody for $1 million, what you're suing is not actually the person, you're suing this iPad in Rem. Well, guess what? The iPad's worth, what, a couple $100, right? There you go, and that's it. Third and finally, in Rem and Quasi and Rem judgments do not get the benefit of enforcement via full faith and credit. Okay, you get an in Rem judgment, the only place it's enforceable is against that property in that state, and that's it. In personam, in stark contrast, if you get an in personam judgment against somebody in Florida and it's valid, you can then enforce it in California and Georgia and Pennsylvania and so on. So in personam, a lot better to have. So that's our next topic for discussion, in personam jurisdiction. Now remember, we're talking about state court jurisdiction here, right? And we're talking about in personam jurisdiction in state courts. And we know that when measuring in personam jurisdiction in state court, we want to look at two things, right? Number one, the state's long-arm statute, and number two, 14th Amendment due process. Remember that for jurisdiction to exist, it has to be authorized, right? There's got to be some sort of law authorizing jurisdiction. That's what a state long-arm statute does, right? It authorizes the courts of that state to exercise PJ. And then the 14th Amendment due process clause is not an authority to exercise PJ, but rather a limitation on PJ. So one way of looking at it is the long arm is the authorization, and PJ is and the long arm is the authorization, and 14th Amendment is the limitation. Another way of looking at it is the long arm gives the scope of permissible PJ authorized by the state, but you still have to satisfy the 14th Amendment due process. However you articulate it, both steps must be satisfied. You must satisfy the state long arm, and additionally, the 14th Amendment must be satisfied as well. Okay, or if you want to put it differently, you can't violate the 14th Amendment through application of the long arm. Now, let's talk in detail about the state long arm statute. There's a number of long arms, and we had a really interesting discussion of long arms the other day, and I thought that the way we have it up on the board might be a helpful way of conceptualizing it. First, there's unenumerated state long arm statutes. California's is an example of that. Okay. Now, it's often said that the state long arm statutes go to the full extent of due process, which is true, but actually they're typically phrased a little bit more specifically than that. So they might say something like this. Personal jurisdiction can be exercised by the courts of the state to the full extent permitted by both the U.S. Constitution and the Constitution of this state. Okay? So actually, the unenumerated long arm is constrained not just by the U.S. Constitution, but maybe by the state constitution as well. Now, in this class, we're not studying state constitutional laws, but I'm giving you a heads up. Unenumerated doesn't just automatically mean full extent of the U.S. Constitution. You may have to consider the scope of the state constitution as well. For purposes of this class and our essays and all of that, we're not going to worry about state constitutions, okay? So what we'll be thinking about is unenumerated means if it's okay under the due process clause, then it's okay under the state long arm as well, okay? Very easy analysis, right? They kind of collapse into the same thing. Then you have what I'm going to call two different kinds of enumerated. The first kind is the enumerated laundry list. New York has that, right? We saw that in the Ben Susan case. Illinois has that, right? A laundry list of the various bases that permit personal jurisdiction to be exercised by the courts of that state. Okay? Now, when you have an enumerated statute, you're going to have to engage in statutory interpretation. And we saw an example of that in the Ben Susan case itself, right? Because in Ben Susan, we had a long-arm statute that said there's PJ over defendant if they commit a tortious, I believe it was tortious act in this state, or something like that. There was a tortious act in this state. And what made it difficult is the website that led to the lawsuit was based outside of New York. The alleged injury the plaintiff occurred in New York. Okay? Well, the Ben Susan court said that an out-of-state website that leads to an in-state injury isn't a tortious act within New York. But guess what? Illinois courts reached the opposite result. Okay, that was the Gray versus American Radiator, then the portion of the opinion that dealt with the Illinois long-arm statute. And that court said that the tortious act isn't complete until there's an injury, and since the injury happened in Illinois, that therefore the act was in Illinois. Now, here's the important thing to consider. When there's statutory language to be interpreted, consider what interpretations can be made. And if you have case law that supports various interpretations, then you can use those cases as authority. Unless I'm telling you to use the New York statute or the Illinois statute, you don't know what the court is going to interpret the statute to mean, right? So you've got to consider arguments and counter-arguments. So I'm less concerned with what your right analysis is, but rather that you consider what plausible argument and counter-argument can be made, right? And what does that tell you about an enumerated long arm? If there's an enumerated long arm in an essay fact pattern, that means you've got to talk about it, right? And do statutory construction, consider analysis, and consider counter-analysis, right? Whereas if it's an unenumerated one, you got to note, hey, this puppy goes to the full extent of due process, and if due process is satisfied, we're golden. And then later on, if you conclude the due process is satisfied, then you say, and by the way, since due process is satisfied, so is the long arm. Or if you conclude due process is not satisfied, say, since due process is not satisfied, neither is the long arm, right? That's it. So enumerated statute means you got more work to do. But that would also mean that maybe I would have less issues somewhere else. If you look back through my old essays on the website, you'll see examples of PJ essays that have unenumerated statutes, and last year I did one with an enumerated statute. More stuff to talk about. Here's another thing to note about enumerated statutes that you should keep in mind. Some states have interpreted their enumerated statutes to extend the full scope of due process. In other words, by judicial fiat, boom, ipsy dixit, magical decision, that even though it's enumerated, the long arm, we're going to treat it as if it were unenumerated. The Illinois courts have so read their long arm statute. Okay. Now note enumerated specialized that I have right here. Okay. What do I mean by that? Well, Glannon, as I recall anyway, kind of lumps together statutes like Illinois and New York on the one hand, and specialized statutes like the one at issue in Hess, the Massachusetts motorist statute, right? And the property statute at issue in Shaffer, and the later statute that Delaware did to exercise PJ over officers and directors, okay? And he's right, okay? They're enumerated, but I'm going to call them enumerated and specialized statutes, because what it does, a statute like this does, is it lists the basis for PJ, typically a very specific one, and it covers a specialized situation. So, for example, the Massachusetts motorist statutes at issue in Hess, okay? Guys, that statute is still on the books today. Now, I'm not an expert in Massachusetts law. I'm going to assume that Massachusetts additionally has a more generalized long arm statute. Is it enumerated? Is it unenumerated? I have no idea, okay? But that means what the lawyer does when analyzing PJ is going to consider what kind of statutes might apply. Now, don't worry about it for purposes of the exam. What I mean by don't worry about it is don't worry about memorizing the New York or the Illinois long-arm statute. If a long-arm statute is at issue, I will give you the relevant text. Okay? The exam itself will say, and here is the long-arm statute. Boom. There you have it. And then you run with it. You do your analysis. Boy, oh boy, this room has gone in like 5 minutes from being 90 degrees to being 60. Am I right? Yeah. Like, ugh. All right. At least I get to move around. All right. And finally, sometimes a state doesn't need a statute or a rule for there to be PJ. What I'm referring to here is the inherent power of the court. Okay? Go back and look at what Glannon has to say about this. This is in the long arm chapter. Glannon points out that there's some authority that a state court may have inherent power to assert jurisdiction in the case of tag jurisdiction, because tag jurisdiction is really, really old. So if you have a fact pattern involving tag jurisdiction, you might consider whether or not you don't even need a long-arm statute, because the power of the state court to assert PJ, the state power, the state authorization, is inherent within the power of the court itself. But by my understanding, the inherent power is limited to tag jurisdiction. If it goes beyond that, I'm not aware of it, and that would be a research project. All right, so remember, we are on state court impersona jurisdiction, which means look at the state long-arm statute plus 14th Amendment due process. So now, under the 14th Amendment due process, we're going to consider first traditional bases, and second, we're going to move on to the modern basis, minimum contacts. Traditional bases. Okay. Basis number one, domicile. All right, Penoyer versus Neff talks about domicile as being a traditional basis for personal jurisdiction. Okay, there's a later Supreme Court case, Milliken versus Meyer, that said domicile is sufficient for PJ. So we could look at domicile as being an example of a traditional PJ under the first principle of public law, right? You're domiciled in the state, and therefore you're located within the state, even if you've gone off, right? So long as your domicile is in the state, there's PJ over you. Traditional basis. Word of caution here, though. Recall our study of the Daimler case. Remember Daimler concerning general jurisdiction? And Daimler talked about Goodyear. Well, in Daimler, the court was assessing jurisdiction using the minimum contacts test, right? And said that jurisdiction over an individual will be measured by its domicile. The court there was not talking about traditional jurisdiction under Penoyer so much. It was talking about minimum contacts test. So it's really, maybe it doesn't matter one way or another, but it seems, at least to me, unclear whether or not domicile is now an example of traditional PJ under the first principle, or an example of ironclad general jurisdiction under Daimler and Goodyear, right? I mean, in terms of the result, it doesn't seem to make a difference. If it makes a difference, I certainly can't think of one for reasons that will become more apparent later. But it might be an interesting thing to note that if you have domicile, say, well, not clear whether it's traditional or whether it's now general jurisdiction, pursuant to what Justice Ginsburg had to say in the Daimler case. And keep in mind that what Justice Ginsburg said about general jurisdiction and domicile in the Daimler case, really it may well be dicta, right? Because the issue in that case was not general jurisdiction over an individual, was it? It was general jurisdiction over a corporation, right? And sometimes the Supreme Court does that. They talk as an aside about something as if it's the law, but then later on the court will say, well, that's not something we actually reached in that case. We were thinking about it, and this is what we meant. An example of the court grappling over the scope of the statement about how broad it was or whether it meant what it said was, of course, a burden, right? Where the court's fighting over the meaning of what the court earlier said in Marshall's opinion in Shaffer. So, just as an aside, so I'll actually literally go to the side, because this is a side comment. All these cases we've read, how many have we read? About 10,000? There's been a lot, right? This has been your introduction to constitutional law as a 1L. And you've gone through a really rigorous study in depth of a series of cases grappling with the same base question, personal jurisdiction in a variety of contexts. You see how the law evolves from case to case to case. Court says X, then it says, well, now it's Y, and then it goes back and says, well, it's still X in certain circumstances. Then it'll say, this is the rule. Then in the next case, it'll say, well, we were speaking too broadly, and we didn't mean that, right? That's kind of how this kind of jurisprudence works, right? So it really isn't until we get to the end and try to put everything together in a big picture that it hopefully starts making sense. Okay, end of the aside. So here we are back in the traditional bases. We talked about domicile. And next we talk about consent and a waiver. And conceptually, like I said, from my own personal analysis, I kind of think of them somewhat together. Conceptually, consent is you've done something leading to PJ. Waiver is you failed to do something leading to PJ. So an easy example of consent is you sign a contract with a forum selection clause. Courts typically enforce those so long as there's a reasonable relationship between the contract and the forum. Or you stipulate to jurisdiction in some other document, like a letter or an open court. You say, okay, I stipulate there'll be PJ. There you go, there's PJ. A waiver is failing to do something. A general appearance. You show up and start litigating in court. You never mention PJ. You're litigating on the merits, and you never make any objection to PJ. Well, PJ, an objection to PJ is a personal right of the defendant that is easily waived if not asserted at the correct time and in the correct way. Okay, there's an example of waiver. All right. Now note that on the last two, we said stipulation, general appearance, form selection clause, sanction. We had a really interesting discussion the other day. Well, is sanction really waiver, or is it really something sui generis? It's its own kind of basis. And you guys made a really interesting argument that, well, it kind of is like a waiver. And I like the argument because in the case of the Bulge case, right, the defendant refused to respond to orders compelling discovery, and by failing to comply with court orders, was deemed to have been subject to PJ, right? So you could look at it as a waiver in that sense, right? But in any case, it's something you've done or haven't done. Here, haven't done. You haven't responded to the court orders, and therefore the court, through the sanction powers under Rule 37, enters an order finding that there's PJ. Implied consent. I have a question mark by that one as well, because we have, for example, on the books, we have the Hess case, right? And Hess says, oh, you drive to Massachusetts and you've impliedly consented to jurisdiction in Massachusetts, and there you go. Well, yeah, I get it, but I don't buy it, because also remember the International Shoe itself says that implied consent was a legal fiction, and that what really mattered were the contacts that the defendant has had with Massachusetts that justified the legal fiction of implied consent. So if you want to argue that implied consent is a judicial basis or it's a flavor of consent, that's fine. But be aware that the Supreme Court has kind of said that implied consent really isn't consent. It's just a legal fiction, and what matters are the defendant's contacts with the state. All right. Next traditional basis, and I believe our last one is going to be transient presence. All right, before we get into Scalia versus Brennan, I want us to remind ourselves that you can't just drag the defendant into the state. Okay, I'm just going to pick you up from your chair, I'm going to drag you into this little box right here. Now you're in Florida, and boom, Tommy Lee's going to come up and serve you. It doesn't work that way, right? You can't use force or fraud to drag somebody into the state. And Brennan, in his concurrence in Burnham, points out the defendant must be in the state voluntarily, right? Justice White, in his concurrence, says the defendant must be there intentionally. That's an interesting discussion, intentionally versus voluntarily. That's a discussion outside the class, but just keep in mind that the defendant can't be dragged there, okay? And that there has to be some sort of, I guess, mens rea, some sort of volitional element or even an intent to be there in order for tag jurisdiction to work, okay? So there's some of the basics. Now, what are the elements of tag jurisdiction? Well, first, tag jurisdiction can only be used against a human individual. So if you're going to sue Xerox, you can't use tag jurisdiction. Doesn't matter whether you're serving the CEO of Xerox personally within the forum state, okay? That's not tag jurisdiction. Tag jurisdiction is over people, not entities. Second, the defendant must be served with the summons and the complaint, and they must be served personally. Okay, that's tag jurisdiction. Don't confuse tag jurisdiction with bulge jurisdiction, right? Tag jurisdiction can be in state court or federal court. Okay, tag jurisdiction requires personal service on an individual. Bulge jurisdiction is federal court owned, right? And bulge jurisdiction doesn't require personal service. It instead requires that the defendant is served, whether a person or a company, whether it's served personally or not. They're served within 100 miles of the federal courthouse. They're served in a U.S. judicial district, and they're joined under Rule 14 and 19. I've seen that in essays in the past where students kind of like treat tag and bulge like they're the same thing, but it's just not the same thing at all. Now, of course, we have the death match between Scalia and Brennan regarding tag jurisdiction. And, I truly do leave it to you regarding who has the better of this argument, Scalia versus Brennan. You know, as we talked about in class, both of those opinions are kind of poorly reasoned, perhaps lending credence to Justice Stevens's point in his concurrence that sometimes, sometimes hard cases make bad law, and sometimes easy cases can make bad law too. So Stevens isn't real impressed with anybody's argument in this case. So Scalia, kind of the bottom line with Scalia is Pennoyer, first principle, boom. What do I mean by that? Well, under Pennoyer, personal service on an individual defendant in forum state meant there's tag jurisdiction, there's personal jurisdiction. That's the end of it. No need to analyze fairness or convenience or reasonableness factors or context. Don't want to know, don't care. Okay? That's Scalia. Now, is Scalia's approach to the law? No, right? 4 votes. Is 4 more than 5? Does 4 equal 5 or more? No, right? He only had 4 votes. All right, Brennan. Brennan says use the minimum contacts test. Interesting. But keep in mind that Brennan's treatment of tag jurisdiction in Burnham kind of seems like general jurisdiction, doesn't it? Because Burnham's contacts with the state of California didn't give rise to the claim. You know, it doesn't really seem to. So since those contacts didn't cause the divorce action, right? They weren't evidence of the divorce action. It wasn't but for him going to California, there wouldn't have been a divorce, right? The wife filed the divorce papers before he went out to visit. You know, I just don't see how there's specific jurisdiction here. So that means that Brennan thinks that you have general jurisdiction based on, boom, go to the forum state, get served, there's general jurisdiction over you. And his analysis is poor, you know, because he basically talks about what? Number one, he talks about purposeful availment, right? You go to the state, if you get sick, they're going to treat you. Boom, I'm saying boom a lot, aren't I? You got purposeful availment. And he says that it would be not burdensome to the defendant. So he talks about the first and third steps of a specific jurisdiction analysis, right? But he ignores whether or not the context gave rise to the claim. So it's a very fishy analysis, and he seems to permit general all-purpose jurisdiction based on a visit of 3 days, right? So how does one analyze Brennan? Well, first it seems like he treats in-state presence and personal service as a super contact, right? You're personally served, it's a super contact permitting general jurisdiction. Okay. Well, keep in mind that the Daimler case may call Brennan's rationale into serious question. And here's why. Remember, Daimler and Goodyear said that general jurisdiction over individuals was typically what? Domicile, right? Did Daimler say anything about tag jurisdiction permitting general impersona jurisdiction? No, it did not. So it's kind of like a formalistic kind of analysis, but if the modern case, Daimler says the general jurisdiction for individuals is usually limited to domicile, and Brennan seems to be engaging in general jurisdiction in his 4-justice plurality, then I have serious doubts as to whether or not Brennan's rationale survives today, okay? So, you know, it's an example of kind of like triangulating the cases, right? What is the current law based on what all the justices have said? So I can't tell you what the law is because the court has never reached a 5-justice majority on the legal rationale that underlies tag jurisdiction. All I can tell you is all 9 justices want there to be tag jurisdiction, but you do not have a 5-justice majority telling us why there's tag jurisdiction. So there you go. There you go. I suppose the way I might consider approaching Brennan is to point out that it's a minimum contacts analysis, that it seems to be a general jurisdiction, right? It's not clear, based on what Brennan says, that how much purposeful availment is enough for there to be general jurisdiction, right? In Burnham's case, he was there for 3 days. Scalia chides Brennan and says, what if you're there for only 2 days, you know, or 1 day? Or you say the defendant is there for just an hour. Is that enough? I don't know, okay? But keep in mind that Brennan is talking about general jurisdiction here. Okay, so let's see. So that's tag jurisdiction. And we've now worked our way, in just an hour, we've worked all the way through all the bases except minimum contacts. We're making really good progress. Now, minimum contacts here's how we're going to analyze it. Let me tell you up front, okay? And then we'll get into the nitty-gritty. First, I want to talk about general jurisdiction, because that ties right back into what we're talking about in the context of tag. Then we're going to talk about specific jurisdiction. And for specific, we're going to talk about 3 steps. Step 1, purposeful availment. Step 2, giving rise. And step 3, reasonableness. Okay? So I mean that is, you know, to be sure that I'm not hiding the ball at all for minimum contacts. That is how I want you to analyze it, you know, the way I'm showing here. So first, general, where do we go? General, here we go, general jurisdiction. Now, general jurisdiction is all-purpose jurisdiction, okay? It's all-purpose jurisdiction. If we have general jurisdiction, then it doesn't matter if the contacts are related to the claim or not. You don't care if the contacts gave rise to the claim. We don't care if the contacts are remotely related to the claim. We don't care if the contacts are completely unrelated to the claim. It doesn't matter. This general jurisdiction is for all purposes. What does that mean? Well, remember how I said for specific jurisdiction, I want you to look at 3 steps, right? Guess how many steps I want you to look at for general? 1. Are the defendant's contacts with the forum state, so continuous, systematic, and substantial, that the defendant is essentially at home? If the defendant's a corporation, then the archetypal places where there will be general jurisdiction would be principal place of business, which is 1 place, and any place where the corporation is incorporated. Now keep in mind, what if I throw out to you other forms of business like an LLC or an LLP? Remember, LLCs aren't incorporated, right? Only corporations are incorporated. I'll avoid throwing that stuff at you because you haven't had business orgs yet, but I guess I'm telling you for purposes of future practice and future consideration that when you get to business orgs, keep in mind that a partnership isn't an incorporated entity, okay? A limited partnership requires filing of papers with the state, but is not actually incorporated, okay? What we're talking about here right now in this class, let's limit it to corporations and people, all right? So corporation, principal place of business, in any place where the corp is incorporated. For people, by people I mean living, breathing individuals. We're talking about domicile, okay? So we have those right there. Now, here's something to be careful about. Here are 3 main bases that I think are going to be like, in my opinion, are going to be the 99% of all of the examples of general jurisdiction. Footnote 19 of Daimler talks about exceptional cases where there might be general jurisdiction because the defendant's contacts are so systematic and continuous and substantial that they're essentially at home, even though it's not a place of domicile, even though it's not a PPOB state, even though it's not a place where the corporation is incorporated. It seems to me that Justice Ginsburg, by using the word exceptional, means that a footnote 20 jurisdiction, you know, kind of the special cases, general jurisdiction, is going to be the rare case indeed, okay? The rare case indeed. So I think the mere fact that a company has lots of stores in the state may not be enough for general jurisdiction under footnote 19, okay? It seems that in Daimler, the court really wants to limit the number of places where somebody could be subject to general jurisdiction. Having said that, if you want to make an argument in an exam regarding a footnote 19, consider the argument and consider the counter argument, right? Why might this be an exceptional case? Why might it not be, okay? As a JD student, I want you to be developing your chops on considering both sides of an issue. So there you go with that. I guess one last thing on general jurisdiction, and this ties into what I said about Brennan a few moments ago, is it's 1 step, right? So all you're analyzing is that essentially at home, systematic, substantial, continuous, those other things. Oh, is that what? Thank you. Thank you. Agua. Thank you.
isn't the why I'm gonna be talking like this.
Something like that. Thank you very much. Okay, so it's one step, right? Essentially at home, all that other stuff I said with the four categories that I just noted, you know, PPOB, Inc., Domicile, and exceptional cases. That means that's the one and only step. You don't have to analyze the relationship. At the most, I point out that it doesn't matter whether the contacts are related or not. In fact, with all purpose, it can be completely unrelated. The suit can be completely unrelated to the contacts. Also, something worth noting in passing is you also don't analyze the reasonableness factors for general jurisdiction. And that's really important because the lower courts were split for many years regarding whether or not, in a general jurisdiction case, whether or not you analyze the reasonableness factors found in Worldwide and Burger King. Okay? Well, in footnote, was it 20, right? Daimler footnote 20, Justice Ginsburg tells us that in the case of general jurisdiction, we don't analyze the reasonableness factors as well. And I think that's another reason why Brennan's approach to tag jurisdiction in Burnham is quite questionable. Why? Well, if we don't look at reasonableness at all, that would mean a mere showing of purposeful availment would establish tag jurisdiction over a defendant that visits a state for only like a day, or 2 days, or 3 days, right? So Brennan's rationale is really quite questionable at this point. All right, so that's general jurisdiction. Specific jurisdiction, or case-affiliated jurisdiction. The specific jurisdiction is when the defendant-initiated contacts give rise to the claim, right? And the exercise of jurisdiction would be reasonable. Well, as a starting point, let us recall that chart that we did in class, right? And the reminder from Shu that as the quality and the nature of the contacts become more pervasive, the easier it is to show specific jurisdiction, right? In fact, Shu itself was an example of an easy case of specific jurisdiction. Why? Because the International Shoe Company, based in St. Louis, had continuous and systematic contacts with the state of Washington through its salesmen who were in the state for years, selling what today would be a significant sum of shoes, right? Those contacts of the company with the state of Washington gave direct rise to the tax obligations that were sued upon, right? So keep in mind, the specific jurisdiction doesn't mean one or a few contacts. It just means that there's contacts, which gave rise to the claim, right? Now, what's important to keep in mind about the quality and nature of the contacts is the more pervasive the defendant's contacts are with the forum state, the more they go from being single and isolated and fortuitous on the one hand to becoming continuous and systematic on the other. Well, if you're overhearing continuous and systematic, then you're very likely to have personal jurisdiction, right? Subject to the reasonableness factors, right? Whereas with a case where there's only one contact, or a few, or they're isolated or fortuitous, well, maybe there's PJ, right? That's not an easy case of PJ. That's a harder case of analysis. And, and we're going to care very deeply about the reasonableness. We're going to care about the connection and so on. But of course, we care about all the factors. So let me elaborate. So the first point about specific jurisdiction was a reminder that the more pervasive the contacts, the easier it is to get PJ under specific jurisdiction, but you still got to satisfy steps 2 and 3 of the test. So let's go through each of these 3 steps. And to summarize, step 1, minimum contacts showing purposeful availment. Step 2, contacts giving rise to the claim. And step 3 are handy-dandy reasonableness factors. All right, step 1. Minimum contacts showing the defendant has purposely availed itself of the privileges and benefits of the laws of the forum state. This is a non-negotiable requirement for personal jurisdiction under the minimum contacts test. Absolutely required. Remember what Justice White said in Worldwide. Even if jurisdiction would be reasonable, even if there would be little burden on the defendant, even if the state had a manifest interest in hearing the claim, there's no jurisdiction unless the defendant has contacts with the state. And the contacts that matter are not the plaintiff's contacts. The contacts that matter for the step 1, purposeful availment, are the defendant's own intentional contacts with the state. So worldwide Volkswagen, right? The car dealer didn't sell any cars in, what was it, Oklahoma. Okay, didn't sell any cars there, didn't advertise there, had no contacts with Oklahoma. The plaintiffs say, aha, but the car dealer and the car distributor sold a car knowing that it would be driven to places that included Oklahoma. The court said, the unilateral activity of other people, such as the plaintiff, don't matter. The activity that matters is the activity of the defendant. Why? Well, number one, quid pro quo. Okay? Quid pro quo. Quid one thing for another. You go to the state, you get benefits and protections from the state and its laws. The police protect you. The hospitals will admit you, and so on and so forth. There's laws that favor you. Okay? You can take advantage of the court system in the state. So the defendant gets benefits. Second, purposeful availment focuses on the defendant's intentional contacts with the state, which means the defendant can make the choice to engage in those contacts or not. So you go back and look at worldwide, what the court says there is it's concerned with the phrase is just slipping my mind. I forget the phrase, it'll come to me in a few minutes, but the basic life conduct of people. If we focus on the defendant's contacts, then the defendant knows that he or she or it will have the choice as to whether or not to make contacts with that state. Or if they don't want to be subject to personal jurisdiction there, they avoid having contacts. Or if they want to make the contacts, but they fear being sued there, they can procure insurance, right? Or they can hire lawyers to look into the potential liabilities, right? So focusing on defendant contacts allows defendants to plan out what they're going to do and where, okay? Now, purposeful availment is required. Here's where students oftentimes get confused, okay? How do I analyze purposeful availment? So I'll see in essays where students will say, here's my analysis of minimum context, and here's my analysis of purposeful availment, and here's my analysis of stream of commerce, as if they are all three separate things. They are not. Okay, this first step requires you, providing the analysis, to look at the defendant's own contacts with the state, okay, those quid pro quo defendant-initiated contacts, and ask whether or not the defendant has reached out to the state. Then all these other things up on the board are various ways of demonstrating purposeful availment. Okay? Now first, you could engage in what I'll call is just a regular old assessment of the quality and nature of the contacts. Okay? You just discuss the contacts. However, we have a whole bunch of cases and tests for ways of assessing purposeful availment in specialized scenarios. For example, taxes. Well, we have a precedent, right? International shoe. Negligence. The Hess case, as shoe itself reinterprets, right? After shoe, Hess is about somebody who goes to a state, negligently causes a car accident. Did the defendant purposely avail himself to the state? Yeah. The defendant chose to go to the state. The defendant benefited from the roads and the nice clean roads and the police that kept the roads safe and so on and so forth, okay? That's purposeful availment. You drive up to Georgia to go to Atlanta, you're purposely availing yourself of Georgia. You cause an accident there that gives rise to a claim, then there's specific jurisdiction subject to the reasonableness factors, right? So Hess, as reinterpreted by Shue, is an example of negligence. Contracts. We have Burger King, right? Burger King, a wonderful and woefully unhelpful case, because it's an easy case of PJ. Why? Because you have this like multi-year contract worth millions of dollars negotiated by sophisticated parties with all kinds of anticipated future consequences, right? Well, what about your one-shot contract? Does Burger King give us a lot of guidance? No, it doesn't, right? But Burger King does give some small amount of guidance. Think about, for example, the negotiations, right? Think about the terms of the contract. Think about the anticipated future consequences. Think about the course of dealing under the contract. Those are all relevant considerations. Now, having said that, in commercial dealings that might lead to a breach of contract, today Burger King isn't real important for the most part, because typically there's going to be a forum selection clause, right? Now, Burger King itself, apparently Burger King couldn't use a forum selection clause because of relevant state law that prohibited forum selection clauses in franchise agreements. So what Burger King instead had was a choice of law clause. Be clear on the distinction between a forum selection clause and a choice of law clause. Forum selection clause says something like this: any disputes arising under this agreement shall be litigated solely in the state or federal courts located in Dade County, Florida. Forum selection clause says where any disputes must be litigated. Here's another example. Any disputes arising under this agreement may be litigated in the state or federal courts in Dade County, Florida. That means that down here in Florida is one place where it can be litigated. Note how I said may instead of must, right? So that would leave open the possibility of other places as well. Let's contrast all of that, the choice of law clause, which is what is at issue in Burger King, where the contract said something like this: any disputes arising under this agreement shall be decided by reference to the contract and other laws of the state of Florida. Okay? That just tells us what law the court is supposed to use in resolving the dispute. Brennan says in the case that the choice of law clause is showing more reaching out to Florida. It's more indicative of purposeful available to Florida, but was not by itself a determinative. In contrast, a forum selection clause, assuming it's enforceable, and they typically are, will be determinative and will be pretty much the end of the analysis. Okay, contracts. Intentional torts. That's an area that's in flux right now. We had the Calder case in the case book, right? We had some excerpts from that. And that requires first an intentional tort, right? So we're talking defamation. We're talking certain business torts that have an intentional element, like intentional trademark infringement, intentional copyright infringement. And in cases like that, the intent element is likely to be met. The second part under Calder is that the brunt of the injury must be felt within the forum state. Okay? So the plaintiff must be feeling the main injury in that forum state. So think, for example, Shirley Jones in the Calder versus Jones case. She lived in California, she worked in California, that's where her whole life would be ruined. Okay? And then the final step was the brunt of the defendant's conduct must be aimed at the forum state. Okay, so in Calder, the story itself was about things that were alleged to have occurred in California. Okay, now the current state of the law is in a bit of state of flux because of the Walden case, and we discussed it in class. I have excerpts from the case posted to the website. It's only about that long. It's a very quick read. In my opinion, the gist of the Walden case is that what really matters are the first and the third steps. The court is less concerned with where the injury happened. And what really matters is that it's an intentional tort, and the defendant is aiming its conduct not at the defendant the defendant is aiming its conduct not merely at a plaintiff located in the forum state, but the conduct is itself aimed at the forum state and the residents of the forum state. Okay? So I think that what we have in Walden is another case of the Supreme Court trying to narrow the scope of personal jurisdiction just a little bit, just like it did in Walden. Okay. Internet contacts. All right, we didn't cover this in class, but I'm just going to tell you a little bit about it. Okay, so you know a little bit about it. All right, internet contacts are typically measured in a couple ways. The first is by use of the Calder test. In cases involving internet infringement, like domain name cyber squatting, or trademark infringement, or copyright infringement, courts are very quick to use the Calder test because willful intellectual property infringement is akin to an intentional tort, and courts will use Calder. It's been used quite a lot. I think we noted that in class. Second, courts will use something that's called the Zippo Test, which was created by a federal court in Pennsylvania by Judge McLaughlin in Western Pennsylvania. And the Zippo Test looks to the interactivity of a website and the commerciality of a website. And very, very simply put, the more interactive and more commercial a website is, the more likely there is to be PJ against that website in the forum state. Okay, so for example, if you just post a page to the internet saying that John Jacob Jingleheimer Schmidt is a fraud and a thief, okay, and that's all it says. What we have here is a non-commercial site, right? And it's a passive text, all right? So Zippo would not permit jurisdiction, though Calder might, because defamation is an intentional tort. However, let's think of Amazon. You go on the Amazon website, and there's lots of information exchange. You're entering into repeated contracts. You're buying goods through the site, okay? Amazon, under the Zippo test, would be much more likely to lead to a case of personal jurisdiction, okay? So that's an easy case of PJ under the Zippo test. Now, as a side note, you know, Zippo doesn't matter for Amazon, right? Because if you go to the terms and conditions of Amazon's website, what's going to be in its contract with you? A forum selection clause, that's right. So Zippo has some application, but not always. I think that the state of internet jurisdiction is going to be under a lot of flux now, and here's why. Zippo was written by Judge McLaughlin, I think, in 1998, back when the website consisted of, back when the internet consisted of websites, right? The internet today is much different, isn't it? We have apps, we have widgets. The nature of interactivity and the nature of communication of information over the internet is much different today than it was 10 years ago. You go on Facebook, well, something posted on Facebook, Facebook's what, in California, right? But the stuff that's on Facebook doesn't come just from California, it comes from people all over the world. So the jurisdictional analysis will become a lot more complicated. I think perhaps that's one of the reasons why the Supreme Court has yet to take on an internet personal jurisdiction case. I think that the Supreme Court is scared to death of screwing up jurisdiction from the internet, because the internet's kind of everywhere and nowhere at the same time. Okay. We have yet another way of demonstrating purposeful availment, and that's stream of commerce, right? And the law there is very unsettled because of Worldwide, Asahi, and the Castro. But keep in mind that Worldwide itself said the stream of commerce is good. That's a good basis for purposeful availment, right? But the concern about Worldwide is Worldwide wasn't actually a stream of commerce case, right? Instead, Worldwide was giving approval to a theory that didn't actually lead to PJ in that particular case. So maybe the discussion of stream of commerce and Worldwide is just dicta. Well, then you have Asahi and the Apple Court splitting quite vigorously over whether or not stream of commerce is a good theory and how it might be met or unmet. And we have three approaches. The first one is that of Justice Brennan, which I'll call just mere stream of commerce, right? The defendant is aware that its goods are being marketed in the forum state through the regular and anticipated flow of goods to that state, and in such a case, there's purposeful availment, right? So think of the facts of Asahi itself, right? The valves went from Japan to Taiwan, and wherever else they ended up before they ended up in the tire, in the motorcycle, before the motorcycle was sold in California, and then the valve may have led or contributed to the accident, okay? And the defendant probably should have anticipated that its valves would go into California. In fact, probably anticipated that its valves would be everywhere in the world, right? For Brennan, that would be enough. And there were many thousands of valves that may have been going into California. O'Connor, in contrast, is not satisfied by Brennan's mere stream of commerce. So O'Connor requires what we call stream of commerce plus. Additional conduct may be required. She gives examples of designing the product for the forum state, advertising in the forum state, establishing advice channels in the forum state, or marketing through a distributor who's agreed to serve as a sales agent in forum state. So for O'Connor to be satisfied, two things have to be met. First, you have to satisfy the Brennan test, right? Basic stream of commerce. And additionally, you got to satisfy one or more of her plus factors. Now I'm going to make another aside here for a moment, okay? The book tells you that Nicastro is not in the book, but it's a recent stream of commerce case from the Supreme Court. Nicastro, the court again split. We have no majority, okay? And the book tells us that Nicastro is got analysis that's very similar to Brennan's and O'Connor's and so on and so forth. Actually, it seems that the analysis of the pro-O'Connor justices in Nicastro have an even narrower version of what O'Connor says in Asahi. I don't expect you to know what Nicastro actually says for the exam, okay? But I expect you to know for the exam is the three approaches that Asahi provides us, plus the fact that we have worldwide out there that embraces it. That I expect you to know. Also expect you to know that Nicastro hasn't settled the issue of stream of commerce. But actually, out in the real world, when lawyering actually matters, you would want to definitely read Nicastro and other cases to follow up on it, because Nicastro actually seems to use O'Connor's theory even more strictly than O'Connor herself would. And if you want to talk to me outside of that, outside of class regarding that, I'd be very happy to. All right. Finally, we have a third approach, which is that of Stevens, which looks to the volume, value, and hazardous character of the components. Well, normally I'm a huge fan of good Justice Stevens, but I have to say that I don't know how helpful his factors are here, because think of the case of Asahi itself. The volume of valves, thousands of them, right? Well, that tilts towards PJ, I guess. The value, how much is a valve? I don't know, the book says, what, like a quarter, a nickel? Not a lot, right? Value suggests, well, that's not enough money to hail Asahi all the way from Japan to California. Hazardous character. Well, what can a bad valve do? It can kill you, right? So that tilts towards jurisdiction. Well, I would imagine Stevens doesn't look at this as a kind of numerical analysis. Well, two of them point towards PJ, one of them doesn't, two is more than one, so there's PJ. Seems like he wants to look at the totality of the circumstances, right? But I think you're going to have a lot of fact patterns out there where the volume is high but the value is low, right? Or the value is high but the volume is low, right? So I don't know that Stevens' analysis is all that helpful. What do you do in an exam? If you have a stream of commerce fact pattern, make sure to analyze all three, right? There you go. What's the answer? I don't know. Or doesn't know. Why the heck would I know? Why the heck would you know? What does matter is your ability to point out the law is unsettled, point to different versions of the law, and for each version of the law provide cogent analysis, and if applicable, any cogent counter-analysis. You see how I have all this split up? It's like a big old flow chart, right? In any one exam, some of these things will be applicable and relevant, some of them won't, right? So when you know the law, you think about what branches do you need to go down. Okie doke, so there we go. There's purposeful availment. Now, step 2, contacts giving rise to the claim. Remember, we're talking about specific jurisdiction. This is step number 2. All right, so the book's talked about 2 tests and alluded to a third. Let's make sure we talk about all 3. First is there's the evidence test. In other words, the contacts of the defendant with the state. You know those contacts you identified in step 1, purposeful availment? Well, in step 2, you ask, do those contacts, are they evidence of the plaintiff's claim, right? So you got to think about what things would the plaintiff have to prove in court to win, right? And then ask whether or not those contacts serve as evidence, okay? That's the evidence test. The second is the but-for test. Now, you guys have already had negligence now, right? So you know all about but-for causation, right? So but for the defendant having contact with the state, there would have been no claim. So we have the examples in class and in the book about, the resort off of the state. There's an ad. You can go back and look at those typos. Now, the third possible test. Some courts may use a different approach, okay, which is a broader approach, asking whether or not the defendant's contacts are somehow sufficiently related to the claim, all right? So, in other words, if evidence and but-for are both unsatisfied, we'll still consider what is the relationship between the contacts and the claim itself. Might be concoct some sort of argument. Sometimes the Landon book tries to simplify things down to like, well, here's one test, here's another test. But he is careful to tell you that here's one common approach, here's another common approach, and he tells you. And courts might take other approaches as well. Well, this is an example of some of those other approaches. That the contacts didn't serve as evidence, they did serve as a but-for cause of the claim, but somehow they might be related to the claim, and that's for purpose of doing creative analysis. Finally, look at this. We're on the bottom right-hand part of our huge chart here. The reasonableness factors. Okay, make sure you give yourself enough time to talk about the reasonableness factors. First reminder: reasonableness factors apply to specific jurisdiction, not to general jurisdiction. Why? See Daimler, footnote 20. Second, if the defendant has purposely availed itself of the forum state, then reasonableness of jurisdiction is presumed, right? And then the burden now shifts to the defendant to show a compelling case of unreasonableness. That's actually quite important, because if you're kind of shaky on whether or not there's reasonableness or unreasonableness, this burden shifting framework makes it really hard to show enough unreasonableness. Because for there not to be personal jurisdiction, when there is purposeful availment, and when the contacts do give rise to the claim, well, there's going to be jurisdiction unless the defendant shows that it's really, really, really unreasonable, compellingly unreasonable, right? That's hard to show. That's hard to show. For example, think about the Asahi case. Suppose Mr. Zerker remained a plaintiff in the case, and Mr. Zerker asserted a claim against Asahi itself, right? Well, gee, the factors come out differently there. Arguably so, right? Because Zerker has an interest in litigating in California. California has an interest in protecting its residents. Much of the evidence will be in California. Is it burdensome for Asahi? Sure, but hey, California tort law is probably going to apply to this claim. And, there's some burden, but the other factors kind of weigh against that burden, which means, is it unreasonable for Asahi to litigate a claim by Zerker against Asahi? A little bit. Is it compellingly unreasonable? Perhaps not, right? So keep that burden shifting framework in mind and apply all the factors. Think about arguments that might be made. What is the burden on the defendant? Is the defendant far away? Is the defendant from a foreign country? Is the defendant going to have to deal with a foreign legal system, right? Interest of the plaintiff. Well, why is the plaintiff litigating in that state, right? Is the plaintiff a citizen of that state? Plaintiff's at home? Is the plaintiff litigating where the injury happened? Is the plaintiff instead litigating in a place which is the only place where a plaintiff thinks it can get PJ? Why is the plaintiff filing suit here? The foreign state's interest. What interest does the state itself have in the subject matter of the lawsuit and these particular litigants, right? Remember, in Asahi proper, the actual claim at hand was a claim for indemnification between Shengshin from Taiwan and Asahi from Japan, and the state had basically no interest in that claim that arose between two Asian companies concerned indemnification over a business deal from Asia. All right? And finally, efficiency and substantive social policy. Efficiency, we're talking about things like where the witnesses are located. We're talking about where evidence is located. What's the most convenient place to litigate, right? Is this a convenient place to litigate, right? Finally, substantive social policy. I've never seen the Supreme Court actually rely on this factor, but what you're looking at is what is substantively at issue? Is it a contract claim? What are the substantive issues arising concerning contract claims? Is it a product liability claim? Do the states have a shared interest in allowing plaintiffs to pursue claims for product liability? Considerations like that. And we reached the end of our chart. So here is what you and I have just spent the past month of our life on. All right, so what I'm going to do is we'll turn off the camera, I'll take any questions you have, we'll take a break, and then we'll come back and do the problem set. Fair enough?
Yeah.
All right, thank you.